Good afternoon, Berkeley Law community, students, faculty, staff, alumni, friends. My name is William Fernholz. I'm the Director of Appellate Programs here. Could I ask you please to all take your seats and be ready for the festivities. I am going to turn the microphone over to our Dean Christopher Edley, who will say a couple of words. And then after that, Karis Gong will tell you the things you're supposed to do and not do. Okay, thank you.
I just want to do three quick things. First is obviously to welcome all of you. By the way, are there any undergraduates here by any chance? Terrific. That's terrific. I am confident that you will be inspired. I not to go to medical school or anything like that, but because you have two, I am told, extraordinary oralists to hear from tonight, and three of the most thoughtful jurists in America presiding. It's really an extraordinary evening. So that's number one. Number two is I wanted to acknowledge that tonight's competition is the culmination of an elaborate process. And many students have participated, and many students participate more broadly in our appellate programs. I'm hoping that at the end of the program, Bill, will you say a little bit more about the appellate advocacy program while the judges are deliberating? And I wanted to take this opportunity to congratulate all the Boalt students who participate in McBaine and the rest of our advocacy programs. I know that for you, it's been a wonderful experience, and I am completely confident, trust me, you'll remember it for the rest of your lives. But the third thing I want to do is a special thanks to Bill for his leadership and for his patience on very thin resources, stitching together quite a rich program in appellate advocacy. And the fact that we have such a special night ahead of us is a tribute to our competitors, to our law school, but also to the hard and good work of Bill Fernholz. So thank you, Bill, for the Okay, I want to turn it over to the clerk of the court. And I want to remind you that the clerk has the power to, you see these federal marshals sprinkled around. So you better pay attention to what she said. Okay? Karis?
Thanks, Dean Edley. We'd especially like to thank Dean Edley, his office, and the more than 60 volunteer judges who evaluated briefs and arguments over the last few months. This year's McBaine competition was of exceptional quality, and the students' briefs and oral presentations were spectacular. Tonight's arguments represent months of hard work by our finalists, Brent and Patrick, and it's a real treat for us to host such a distinguished panel of judges tonight. Out of respect for our presenters, we ask that you kindly abide by the following court rules. First, please remain in your seats at all times during the arguments. Second, we ask that you turn off your cell phones and refrain from texting. Third, please refrain from using flash photography this evening. Banners and signs may not be displayed and will be removed from the auditorium. And finally, please remain silent throughout the oral arguments. Each side has 30 minutes, including 5 minutes for the petitioner's rebuttal. Hold your applause until after the judges have left the stage. Thank you again for coming, and please enjoy the program. All rise. The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court. You may be seated.
Case is the American Civil Liberties Union versus the National Security Agency. The petitioner, Mr. Badgent.
I'll pour some water.
Good evening, Mr. Chief Justice. May it please the court. I'm Patrick Bajan on behalf of the petitioners in this action, the American Civil Liberties Union. May I reserve 5 minutes of my time for rebuttal?
Yes.
Thank you. When the president began electronic surveillance of lawful United States citizens without any judicial oversight or warrants, he caused the petitioners in this action personal, concrete, and serious injuries. The core question in this case is whether he can now escape judicial review of his illegal actions by invoking an evidentiary doctrine. The answer to that question is no, for 3 reasons. First, the petitioners have standing under this court's precedent in Laidlaw versus Environmental Services to challenge the president's surveillance program in federal court. Secondly, Your Honors, the program is illegal under the plain language of the Foreign Intelligence Surveillance Act. And finally, that plain language controls. This court made clear in Youngstown versus Sawyer that no president can break the law, even in the name of national security. I'll begin with standing. We petitioned for reversal of the Sixth Circuit Court of Appeal because it applied the wrong legal test and reached the wrong result in this case as a matter of law. The Sixth Circuit's decision, if allowed to stand, would strip the federal courts of jurisdiction to review presidential actions in the name of national security, and would bar Congress from exercising statutory oversight over presidential actions in the area of national security. That result would prevent petitioners, people who have been injured, people like petitioners in this case, from exercising or accessing any judicial redress. Or
Why, counsel, do you think your clients are going to have their phone calls wiretapped? What's special about their phone calls?
What's special about their phone calls, Justice Breyer, is that our clients represent attorneys, our clients are attorneys who represent suspected terrorists overseas. They represent them in the capacity as suspected terrorists.
You mean the terrorist is overseas, the suspected terrorist?
That's correct, Your Honor.
And what's the classification? What is it that makes of that individual overseas the people whom he says he has, your clients say that they have conversation with? What leads you to think, or what should lead us to think, that they're more likely than that they are likely to have their calls tapped?
I refer you to the record, and well, let me begin by noting that the record itself is not subject to the state secrets doctrine, that we're going to base our entire case on the record here. So,
You have to speak up a little bit.
I'm sorry, Your Honor. The state secrets doctrine does not protect or embrace anything in the record. So when I cite the things from the record, they're not protected by privilege. The state secrets doctrine does not protect.
Well, I'm not interested in the state secrets doctrine. I'm interested in what is it precisely that leads your client to think that a telephone call with, let's call him Mr. Smith, that's one of his clients. All right, why does he think, what is it that leads, where is the allegation in the record that the NSA is likely to wiretap that client, or the call that your client makes?
Your Honor, I'd refer you to the record at 84 and at 90 where General Hayden and Attorney General Gonzalez have said things like, quote, there is a logic to the program, or that it is targeted and focused. And
yeah, but the question is not whether the program's targeted, but whether there's any facts in the record from which we can conclude that your client's reasonable basis for worrying about being tapped is realistic. I mean, how do we know that? I'll give you an example. One of your clients, you have 2 clients who are immigration lawyers, right? And they represent clients abroad. That's all they tell us.
Yes, Your Honor.
How do we know that their clients, or the people they need to talk to on behalf of their clients, are likely? In other words, how are they likely? You mentioned Laidlaw, right?
That's correct.
In Laidlaw, the plaintiffs there, at least, we knew that mercury had been dumped into the river, right?
That's correct.
And they lived near the river. So there was a basis for us and for the government to assess whether your views about the risk of being tapped were reasonable. All we have here from these two immigration lawyers is they say, we have some clients in Europe. That's it.
Yes, Your Honor. Let me narrow the focus here. We only need one petitioner to establish standing.
Well, which one do you have?
Let's pick Nancy Hollander. She's in the record.
Okay, yeah, let's talk about Nancy Hollander.
She's in the record at 122.
Yeah. So she represents the Holy Lands Foundation, right?
Yes, Your Honor.
Okay. And the only thing she tells us about that, and it's under indictment in Texas, correct?
That's correct.
Okay. So she's not worried about being tapped, having her conversations with the Holy Land Foundation tapped in the United States. That's not the TSP, right?
It could well be the TSP.
No, it can't be. It's for tapping conversations between people in the United States and abroad.
Your Honor,
So all she tells us about the people she needs to talk to in Europe are expert witnesses, right?
That's correct.
Co-counsel, and the only one she mentions is some barrister in Paris.
That's correct, Your
How
Honor.
do we know that he falls within or is likely to fall within the scope of the TSP?
Your Honor, they're going to be talking about things like jihad, al-Qaeda.
Well, that's what the government hopes, but that's not why the government's tapping them.
Yes, Your Honor, and that's why the government will be listening.
But why them?
Because she represents suspected terrorists, people associated with terrorists, people who fall within the umbrella.
But I didn't think you're claiming, from what I can see in this complaint, that the government wiretaps people who are suspected terrorists. They wiretap calls between the United States and somebody abroad. Now, what I can't find in this set of allegations is what it is about the person abroad and the conversation that leads the government to wiretap such that you have a client who will make a conversation like that one.
Your Honor,
Now, here Nancy Hollander says just what Judge Tatel said. I represent some people here who are accused of terrorism. So?
that's the first step in the analysis. So we know that Nancy Hollander represents people accused of terrorism. We know that the terrorist surveillance program targets communications, international communications, with people accused of suspected terrorism. The interplay here and the standing arises not from just that set of facts alone, but from the intersection of that set of facts and the Michigan rules of professional responsibility, which provide possibilities for criminal or civil liability to attorneys who fail to provide confidential counsel.
Well, just read me the fact. What's the fact? It would have been wouldn't it be the easiest thing in the world to find somebody in the United States who doesn't like it and does the following? I, every month, call my friend Smith, who happens to live in Libya, who loves the Al-Qaeda. And he goes around saying he loves the Al-Qaeda. And what I don't understand about this case is I think there must be some people who both talk to people like Smith and don't like their conversations being wiretapped. So why why hasn't one of those people sued us?
Your Honor, if one of
Or
us...
sued not us, but whoever they sued. Right.
Your Honor, there may well be people like that, but
They're not in this case, and that's what's bothering me.
But, Your Honor, we don't need that person in this case to establish standing here. We have attorneys at law who are forced by their professional responsibilities to provide confidential counsel. They know, based on public admissions about this program, that their phone calls and their electronic communications...
That's the part I don't quite see in the record. That's the part. I have no doubt that if they're being wiretapped, that's a big problem for them. And they're just like the people who live near that polluted river. The only thing I can't find here is a claim under oath that suggests that they're making a phone call abroad, which phone call falls within some criteria that the government is using to wiretap.
Again, Your Honor, I'm going to have to try to satisfy you with Nancy Hollander in the record as somebody who has been communicating overseas.
Well, counsel, let me push a little bit farther then and ask, even if we do know that, why does it give them standing to challenge the warrantless tapping of this third party's phone call? Let's abstract from these facts. Let's say that your client represents organized crime figures in New Jersey and makes frequent phone calls to them, and there's suspicion that the U.S. attorney in New Jersey is illegally wiretapping those people's phones. Now, I can see why the client has standing to challenge the illegal wiretap, but does the person who has communications with the person who's being wiretapped have standing to challenge a wiretap on their phone?
Well, the standing test, Judge McConnell, would be the same. We would apply the injury in fact, causation, and redressability elements to the lawyer's claim.
Well, let's talk about injury in fact, because under the Fourth Amendment, we generally hold that the Fourth Amendment is personal to the person whose rights are being invaded. So, for example, if you're riding in an automobile with the owner of the car, you do not have standing to challenge an illegal search of the vehicle. I would think if you just phone people who are having illegal wiretaps, I don't see why you have standing to complain about wiretaps that are put on their phones.
Your Honor, we haven't briefed a Fourth Amendment claim on this appeal. We framed it under FISA for precisely that reason.
But standing presumably is the same.
No, Your Honor. The standing under FISA, the standing has to be attached to the alleged wrongful conduct by the defendant.
Well, FISA itself has a standard for who an aggrieved person is, and it's the person who's being tapped, which in my hypothetical is the organized crime figure in New Jersey. You're not being tapped. You may be calling someone who's being tapped.
Two observations, Your Honor. The first is that the aggrieved person status under FISA is a standard for an APA-type challenge to an agency action under FISA.
It's what?
To an Administrative Procedures Act type challenge to an agency action by the NSA pursuant to FISA. We're making a
You don't make an APA claim in this case.
That's correct, Your Honor, and that's why the aggrieved person standard doesn't apply to the claim that we're making.
Wait a minute, but you still have to be an aggrieved person under FISA. You have to have a cause of action. Even if you have standing, you have to meet the, you have to be an aggrieved person under FISA, correct?
No, Your Honor.
No?
We're making a separation of powers claim and a constitutional claim to the President's action here.
No, your claim, as I understand it, is that the President is violating FISA.
In a way that he's not permitted to do.
Correct. Therefore, you have to show that you have a cause of action under FISA, which means you have to be an aggrieved person as defined by FISA.
No, Your
Otherwise,
Honor.
you don't have a cause of action.
Our cause of action stems from the President's program and its violation of Congress's mandate that FISA shall be the exclusive means.
But that's you're saying it's a violation of FISA. That's what you're arguing. Otherwise, I mean, right? I don't understand. You gave up your APA claim. You're not arguing that here, and you're now saying you're not suing under FISA.
Your Honor, we're suing under a principle of separation of powers for the statutory violation of FISA. That's correct. But we're not suing as aggrieved persons under FISA. We're suing as persons who've been harmed by a president.
Well, how can you? Well, let's take the other part of FISA. I'm not sure I understand the point you just made. But do you also say? Is it your position also that these communications don't have to be electronic communications as defined by FISA?
Absolutely not, Your Honor. The violation that the President has committed here is he's engaged in electronic communications outside the purview of FISA in a way that FISA does not permit. So,
but let's assume these are not electronic communications as defined by FISA. Okay, that's a hypothetical.
okay.
Let's assume they're not. Then what's your cause of action? And you're not arguing, you're not bringing a Fourth Amendment claim, right?
That's correct. If we concede, which we do not, that
then what's the President violating? If these are not electronic communications under FISA, and if you're not bringing a Fourth Amendment challenge, what's the cause of action? What's the President violating?
that would take away our cause of action. But it's because these are electronic surveillance, electronic...
Okay, well, you just... Are these or are they not electronic? Do these or do they not fall within FISA's definition under one of the four subsections, F1, 2, 3, or 4?
They fall under FISA's subsection F1, Your Honor.
Okay, let's talk about that for a minute. Okay? You want to... F1?
Yes, Your Honor.
Okay. Okay. F1 applies only if the communications are acquired by intentionally targeting the U.S. person, right?
Intentionally
targeting your clients.
No, Your Honor. Intentionally targeting communications that involve the United States person.
That's not what it says. It says by intentionally targeting that U.S. person.
The communication...
And you don't make any allegation about that in your complaint.
Your Honor, the communication between an attorney in the United States and their client overseas is the type of communication that...
Try this. Try this. You represent a lawyer in the United States communicating with someone overseas, correct?
That's correct.
And your argument is that the NSA is listening in on that conversation, right?
No, Your Honor. The argument is that we have a reasonable fear and a reasonable belief that the NSA could listen in on that.
Could listen in on it, okay. But the statute says intentionally targeting the U.S. person. That's your client. And you don't have anything in the record In fact, isn't it most likely that they're not intentionally targeting your client? They're actually intentionally targeting the people in Europe you want to talk to who you think they suspect of terrorist activities, right?
But, Your Honor, there's just no way to have communication without more than one person involved, and it seems like
But it says intentionally targeting the U.S. person. We have to live or die by the words of the statute. Excuse me, you have to live or die by
That's
the words
correct.
of the statute.
That's correct.
Right? And we have to figure out what it means, and I don't see how you get around this language.
Your Honor, this communication takes place between people here in the United States, suspected terrorists overseas. It has, quote, a logic. It's, quote, targeted and focused. There's no
But
reason.
it's targeted on the person overseas. It just happens to pick up your client because your client's phoning him.
And in Keith, this court said that people swept into surveillance, people swept into electronic surveillance by the government. The sort of third parties who are listened to do have constitutional rights and do have Fourth Amendment rights.
But you're not raising those. You're raising a FISA right.
Physically.
But they still have rights, Your Honor. They still
Yeah,
have.
they have exactly the rights that FISA gives them.
Well, and that's the issue here. They've been listened
And
to.
so but they haven't been targeted.
They've been targeting communications between attorneys and their clients overseas.
You don't like the language of the statute, do you?
Frankly, Your Honor, I don't.
Yeah, I didn't think so. Let's try another provision of the statute, see if you like that any better. Try F2. You also claim you're under F2, right?
F2 is more troublesome, I will admit. F1
Right.
is our best shot.
Well, may I ask you a question about F1, F2, and F3, which is, what is the difference, practical difference between wire and radio communications? Because F1 applies to wire or radio, F2 applies just to wire, and F3 applies just to radio. What's the significance of this?
Congress is trying to get at everything, Your Honor.
But each of them is quite different, though. What's the relationship between the rules and whether they're wire and radio?
Whether they're wire and radio or whether they're what Congress is after here in these sections, F1, F2, and F3, is to cover the waterfront.
Are your communications wire or radio?
Our communications are wire. Telephone.
They're only wire.
Wire is included. Wire is the strongest case because wire.
So
includes.
they are wire. So F2 doesn't. So F2 is wire. F3 does not apply because it's only radio.
Again, Your Honor, F1 is our strongest shot. Electronic communications include telephone communications.
Right. So if we thought, suppose we believe you haven't convinced us about F1 and F2. That is, suppose we think that these are not electronic communications as defined by FISA. You lose, right?
I'm in real trouble, Your Honor, and
Right.
I would have to try to refer you to my brief.
Well, I was getting these questions out of your brief. Is there anything in the brief that would explain F1 or F2 in any different way?
No, Your Honor. The brief analyzes F1 and F2 in very
Yeah.
similar terms to the argument here.
Okay.
And I am getting low on time. I'd like to turn to the merits here because all of these questions go to standing. Have we violated FISA? Has the President violated FISA under the plain language of FISA?
But
and under
that
the meaning
is
of the
part of
terms?
that is the merits as well as standing.
They're very intertwined. The point I'd like to make on standing is that the President's violation of these provisions of FISA have caused our attorneys reasonable fear that they could be targeted and harmed. And on one hand, they've got this reasonable fear.
But again, do I have a right to challenge an illegal wiretap on my neighbor if I sometimes phone my neighbor?
No, Your Honor, and the difference is that you don't have a professional responsibility and an obligation to your neighbor. If this is an opportunity to emphasize
If I'm my neighbor's doctor?
perhaps
I
if
have
you
standing to challenge an illegal wiretap on that person's phone.
It would be a hypothetical case, but if you had
Could you give us, is there any precedent for that?
Laidlaw versus Environmental Services would be the closest case. Your Honor,
I'm talking about in a search context or a wiretapping context. Does anyone have a right to challenge an illegal search of someone else's, an illegal wiretap of someone else's phone because they sometimes phone them?
not without showing that they have been personally injured in some
Or
way.
was opposed.
But they're always personally injured. My phone. I don't like the idea that the government is going to be listening to the conversations I have with my neighbor. That injures me. I don't have any doubt that there's injury, but is it the kind of injury that leads to standing? It sounds like a third-party injury, which is too indirect to support standing.
It does, and there might be a prudential problem here in that your neighbor might be in a better position to assert the core rights at stake.
Well, no, you imagine, do you have any friends who use Twitter?
I'm afraid I do.
Now, think of your friend who is the greatest Twitter user in the United States. And you phone that friend, and you tell her or him something really, really interesting. Do you have an expectation that that will not show up on Twitter within the next 24 hours?
No, Your Honor. Not
All right, you know perfectly well it's going to show up all over the place. And so you have no expectation of privacy in what you told him, right?
The distinction, Your Honor.
Now here what you did was phone a gangster, Al Capone, of ancient and blessed memory. Now, are you surprised if it turns out the government was wiretapping Al Capone any more than you're surprised when your Twitter message turns up all over the world?
The question, Your Honor, would be...
Now, it wasn't Al Capone you phoned. It was Osama bin Laden. You see the point?
Yes, Your Honor. If I was Osama bin Laden's attorney, I would have a reasonable expectation of privacy in my communication with him. And as this court said in Fisher versus United States...
So the United States can't wiretap Osama bin Laden because of the fear that one phone call he may receive might be from his lawyer?
No, Your Honor. But the United States has to go through FISA.
Even though Osama bin Laden is abroad and not covered?
Yes, Your Honor. FISA...
Let me help you. You want to get to the merits? Let me help you do that, okay? Your argument is that electronic communications aren't all necessary and appropriate force under the AUMF, right?
That's correct.
That's your argument. Well, don't we owe some deference to the President's interpretation of those words?
Your Honor, this court construes statutes. I would submit that
we do that all the time, and we give lots of deference to places like, the Federal Energy Regulatory Commission. Wouldn't we give a lot of deference to the President of the United States in terms of how he interprets this?
Well, let's begin, I think, with the plain language of the word force, because it's a statute, and the plain language should be the first place we start. Force...
Well, so your point is then that force is clear. We don't owe any deference, right?
That's correct.
Well, military force includes intelligence, doesn't it?
No, Your Honor. This court said in Hamdi versus United States...
Military force does not include intelligence?
It said that military force does not include battlefield capture and detention of persons killed in
But I didn't
US.
ask you about battlefield capture and detention. I asked you about intelligence.
Yes, Your Honor, but battlefield capture...
Like with satellites and things like that.
Satellites and passive surveillance, Your Honor, are far more attenuated and far more removed from force than battlefield capture and detention.
So you think military force can be conducted without intelligence?
No, Your Honor, but...
Well, that's what you... Because if you're wrong about that, that is, if intelligence is included in the concept of military force, then I think you lose your case.
But there's a false distinction here, Your Honor. It's not whether the president can engage in force and whether force therefore requires everything the military needs to function. Some powers are reserved for Congress. Congress said you have to go through...
You just told me we're interpreting these words.
Yes,
right?
Your Honor.
We're interpreting the words of the statute.
Yes, Your Honor.
Okay. And I was asking you why you think the word force is so clear that we wouldn't defer to the president's view that it includes electronic intelligence.
Because Congress has said that when it comes to surveillance, when it comes to electronic surveillance, Your Honor, the president has to go through FISA. The president can still engage in surveillance. This is an important point. He can still spy on Americans, but he has to get a judicial warrant from a FISA court. The question, to really frame the question precisely, it's whether the AUMF authorized the president to ignore FISA. And the answer to that question is no. We're not taking anything off the table here. We're not taking any intelligence gathering abilities off the table, and we're not constraining the president's ability to use force. We're asking this court to compel the president to obey the law as he exercises
But aren't
that.
we really asking what Congress meant when it passed the AUMF, and whether by the term military force it meant all of the various warlike activities that generally take place at war, which might include intelligence gathering?
Let's suppose, sort of for a hypothetical purpose, that it did include intelligence gathering and that somehow the AUMF stands in conflict with the language in FISA and that one of them has to give.
Well, we know which one gives because FISA expressly provides for an exception when it's authorized by another law.
No, Your Honor, because the language in the AUMF is very broad and very general. So it's one word, it's force, and it's going to be stretched to include all of these things.
So where in FISA does it say that the law to which might authorize this has to be narrow?
It's in this court's precedent, Your Honor. It said, like, this court has said many times...
I thought your answer to Judge McConnell would have been that the statute says it has to be express. That's what sub B says, right? It has to be express in order to be an exception to FISA.
That's correct, Your
Isn't
Honor.
that the argument? Which brings us right back to the word force.
Yes, Your Honor.
If force includes military intelligence, why isn't that express?
Force involves military intelligence, or a better way to put it is military intelligence.
In other words, why isn't this a perfectly appropriate interpretation of the statute? FISA, well, let me tell you what it is before you answer the question. Okay. FISA limits electronic surveillance generally. The AUMF authorizes it in connection with military force. So when the president's exercising military force, it's an exception to FISA.
Your
What's
Honor,
the matter with it?
There's no reason to think that Congress believed that FISA would be abrogated with respect to military force.
Well, when the president goes to war, it would be, not when he isn't at war.
Your Honor, when the president goes to war, he may need to draft troops or fund the war. He's still required to go through statutory means to do that. Surely the AUMF didn't authorize the president to institute a
You've just
draft.
answered my question by stating the conclusion. You haven't explained why I can't interpret the word force by suggesting that the word force is to be used in the military context, and the military context must include intelligence. And so that's an exception. When the war is over, the president can't do electronic surveillance without going through FISA.
Justice Tatel, I'm out of time. Can I answer your question briefly?
Sure. You have to ask the Chief Justice that.
Yes. Thank you, Your Honor. The question is not whether the president can use military force, or I'm sorry, can use electronic surveillance under the AUMF. The question is how he may go about it. He can do all of the things that he's been doing now if he goes through FISA. Congress authorized him to do that. Congress said, go out and capture the people who created the September 11th catastrophe. Use the law. Here's a piece of law that will help you. That doesn't mean he can ignore FISA.
Thank you, counsel. Mr. Nakamura.
Mr. Chief Justice, and may it please the court. My name is Brent Nakamura, and I represent the respondent's National Security Agency. Although this case raises important policy issues, it turns on ordinary principles of statutory interpretation and this court's well-settled doctrine regarding standing requirements. This case is not justiciable because of the successful invocation of the state's secrets doctrine. The petitioners in this case falter at the first step of an Article III constitutional standing inquiry. They cannot show in any of their statutory or constitutional claims sufficient injury in fact to establish standing. It is not enough to show that one could merely conceivably be subject to surveillance to meet this court's injury in fact requirement. At most, petitioners have alleged a subjective harm. Such a harm has never been shown to satisfy this court's standing requirements. This court's injury in fact requirement...
Is that Laird you're relying on?
Could you repeat the question, please?
Is that Laird v. Tatum you're relying on?
Your Honor, I'm relying on the Lujan case as to the standing requirements.
No, but in terms of subjective harm.
Yes, Your Honor, that is one of the cases on which we're relying.
Completely different from Laird, right?
No, Your Honor,
Sure.
it's not completely different from Laird.
In Laird, there was no allegations at all of illegal behavior, was there?
No, Your Honor, that's correct. There was an allegation of illegal surveillance, which is chilling the plaintiff's right.
No, but it was all legal.
Yes, Your
Everything
Honor.
the government got you could get from the newspapers.
That's right, Your Honor.
So there was no allegation of illegal behavior.
In Laird, no, Your Honor,
Here
it
we
was a
have,
legal surveillance program.
and the risk there, the court said, was that since there wasn't any, there was no case or controversy. There wasn't anything a court could decide, right?
That's right, Your Honor.
Okay, but here we have a case or controversy, don't we? I mean, the case or controversy requirement is designed, it's a separation of powers issue, correct?
Yes,
We
Your
don't
Honor.
want the courts to function like Congress. Well, is there any risk of that in this case?
No, Your Honor, there isn't. This court has been
That's right, there isn't any risk about it in this case, right? There's no risk at all.
There's no risk, there's no objective risk to the petitioners,
No, there's no risk here that this court, if we decide this case, won't be functioning like a court's supposed to under Article III. We have an allegation that government action, which the government concedes exists, is illegal, right? And we have
Yes.
plaintiffs who claim that they are injured by that.
Yes, Your Honor, that's correct.
So there's no risk here that what the court was worried about in Laird v. Tatum would occur here. We decide the case, We have aggressive parties. It'll be litigated aggressively. There's no separation of powers problem at all.
I misspoke earlier, Justice Tatel. There is a huge problem with respect to the risk stated in Laird with this court acting for a case which is outside of its limited jurisdiction as defined by Article 3, Section 2 in the Cases and Controversies requirement from which this court's standing doctrine comes. As this court noted in its Lujan case, in order to establish the first part of the standing test, injury in fact, the harm alleged...
No, they say that. They say, in their complaint, they say that the NSA obtains names, phone numbers, internet addresses, cell phones of persons deemed suspicious. Okay, they say that. Then it says, and they wiretap, or they obtain the communications of suspicious persons. Then one of these petitioners says he has a client named Mahmoud Kourani. And this client is accused, Mr. Mahmoud Kourani, of being a terrorist. And this client has some relative, a family member, who has the same first and last name. And that person lives abroad. And, says the person who filled out this, Mr. Swore, he says, I phone this person abroad. Now, it seems to me a person who is in the family of and has the same name as a person who is accused in a court case of terrorism must be a suspicious person, however narrowly you define it. And this individual is a person whom the plaintiff here telephones. So, he says there's a government program. I have evidence conceded by the Attorney General they wiretap certain people. This man falls well within that definition, however you do it. I don't want to call him. And moreover, it's illegal what the government's doing. Now, standing. There's an action by the government that hurts him, redressable, of course, and join the government from doing it. Okay, what's the problem?
There are several problems, Chief Justice Breyer.
I thought you might find some, yes.
That's right, Your Honor. The first problem is the notion that the TSP itself is illegal, which we certainly do not concede and will...
No, of course you don't concede it. For standing purposes, you have to assume it.
But second, the harm alleged must be concrete and particular.
Yes, it's concrete and particular. I make a phone call to Mr. Kourani, and this phone call is wiretapped, and not only don't I like it, it's illegal. Boom. And I'm going to call him tomorrow. That's assumed, I guess.
But what is at the heart of this case is the problem of proof that the petitioners have not met their burden of showing standing because they cannot prove that that person who they called was wiretapped or otherwise subjected to surveillance under the program.
I think you're not responding to the questions that the Chief Justice and I are asking you. What we're asking you is to step back from these technical requirements of standing, like injury, traceability. I mean, we use that language, right? It begins to sound like tax law after a while. The reason we ask these questions is to find out whether we have a case or controversy, correct?
Correct.
To be sure that we're not acting like the Judiciary Committee, holding a hearing, correct?
Correct.
All right. The question is, how is there any fear that that will happen given the allegations in this case and the fact that there is a program that the government concedes exists, that people are being wiretapped, and that plaintiffs here are affected by?
As an Article 3 court...
Answer the specific question I'm asking you. Why would we have to worry that we would not be resolving a case or controversy? Because that's all Article 3 is about.
That's right, Your Honor. The worry there is that these plaintiffs can, for two things. The first thing is these plaintiffs have not shown that this program applies to them, and that is always a requirement with respect to this.
They say it applies to them. That's the allegation. They claim, sworn statement, it applies to them. The allegation is not implausible. So you represent the government, fine. Will you say right now that you do not wiretap them?
No, Your Honor, we won't.
Okay, that's the end of that. Now.
Well, what is the precise allegation as to what happens to them?
The precise allegation as alleged by the petitioners is that they have a fear of being wiretapped and as a result have altered their conduct, or that their clients have altered their conduct as a result of possibly being subject to wiretapping. That is their allegation. However, that allegation is a world away from this court's standing jurisprudence in Article 3 justiciability jurisprudence, which notes that there must first be at least an injury or a statute or regulation that applies that will serve to harm and alter the conduct
So
of the
suppose
people
I'm
there.
drinking water from a polluted river, and I don't yet know, because it's something, it's a medical problem that's only manifests itself years later, some sort of cancer. Do I have standing if I allege that I fear that I have contracted cancer as a result of drinking the polluted water?
If, Justice McConnell, you were able to prove that the river itself, like in the Laidlaw case where there are 489 separate illegal instances of mercury discharge, then yes, that'd be a much closer case to standing than today, where the petitioners have shown not a single plaintiff being subject to a single piece of
Suppose
surveillance.
what I show is from time to time, pollution has been, mercury or whatever has been dumped into this river, but I haven't proven that any given cup that I take out and drink has any mercury in it. Isn't that like the allegation here, where the proof is that a lot of, from time to time, quite a few folks have been wiretapped over in Europe and the Middle East, and I fear that my calls have been caught up in that?
No, Your Honor, and the difference is that, with respect to that river, you have taken a drink from a river which you know could, is polluted.
Which is parallel to, I have called this person.
But, Your Honor, that person may not have ever been subject to a wiretap, and the petitioners can never show that
Just like
individual's
the
been subject.
water that I draw from the river may not have any mercury in it.
But with respect, Justice McConnell, the case at bar here has a situation where the reason we're outside the cases of controversy, justiciability argument, where we would have a problem for this court deciding it, is because that case has not been sufficiently developed to the point where it would be a
So
ruling on a
is there
live
a
issue.
problem with this? Why don't we then just send this back? And if the government wants to deny the allegations in the affidavit, it can. But if the government doesn't deny the allegations, then I guess we take it as a given, and then this individual is being wiretapped, and then we have to proceed to decide whether the wiretap is lawful or not. Isn't that a simple way to go about it? I mean, you're not prepared today to deny it, but I guess you could consult with your clients, and you could either deny these individuals have been wiretapped, in which case, if they persist with that, we can have some kind of hearing, or if they don't deny it. You don't deny it. If you don't deny it, fine.
In that case, Chief Justice Breyer, this case would go down, but then there should be no inference drawn from the government's failure or failure to deny the fact that wiretapping actually occurred, and that's because of the state secrets doctrine that we've invoked here.
You have a problem here. I'm not even sure it needs to go back. Let me read you a quote from the Attorney General of the United States. It's at record 67. The Foreign Intelligence Surveillance Act requires a court order before engaging in this kind of surveillance. That's what the Attorney General says. He's saying that the kind of surveillance at issue in this case, he says, this kind of surveillance is subject to FISA. So there's no problem here. We've got a concession from the government that this is the kind of communication that's being surveilled.
Justice Tatel,
Yeah.
the concession should be that this is used in lieu of FISA. It's not subject to FISA requirements. We didn't concede that below, and we don't concede that now before this court.
Well, no, but the Attorney General does, and he is. Is this the Obama administration or the Bush administration?
I'd suppose, Your Honor, it's the Obama
And is
administration.
are you reflecting the position of the new administration, by the way?
Yes, Your Honor, we are reflecting the position of the new administration,
Okay.
who has decided to continue this program.
Yeah, but so what do you do with Gonzalez's statement? He says that these are exactly the kinds of communications that the plaintiffs are challenging are the kinds of communications that are subject to electronic surveillance here.
Your Honor, the very definition of electronic surveillance as Congress has passed in Section 1801F, subsections 1 through 4, does not include the kind of surveillance that's going on here.
Why is that?
Because, as you asked the petitioner before, The definition of electronic surveillance is a very technical and specific definition, which includes a situation where, for instance, in Section 1801 F1, that there would be an intentional targeting of a U.S. person, which is not what happens here and has never been admitted by the government publicly or otherwise, or under the other subsections that that the electronic surveillance was either done inside the United States or done subject to a wiretap or other things, and as a result, by the plain text of FISA, it does not apply to the communications here today. And in fact, Congress amended FISA in 2008 and talked about the exclusive means by which electronic surveillance should be conducted, but left unchanged the definition of electronic surveillance.
Counsel, can you tell me why F4 doesn't apply to this case? We talked a little bit about F1 and F2 with your friend.
Yes, Justice McConnell. F4 does not apply because there's been no proof brought forth by any party anywhere, and there cannot be such proof that the electronic, mechanical, or other surveillance device is located in the United States, which provides for this surveillance under the terrorist surveillance program.
But
as a result, there's no cognizable harm.
isn't that part of the public announcement in the United States that what they do is as communications come through the United States that they are in cooperation with the telephone companies picked up?
No, Justice McConnell, could be just as right that they do the wiretapping or the surveillance outside the United States. And as a result, unless petitioners can come forth and show, which they cannot because of state secrets, that the interception equipment is inside the United States.
Does it all have to be? Don't they just have to show that there is a device in the United States?
They could show that, but they have not done so here.
Isn't that at least strongly implied by the government's concessions?
No, Your Honor, it's not strongly implied or implied otherwise by the government's concessions. The government has made no indications as to where the surveillance occurs and will not make such an indication and continues to invoke the state secrets.
Don't we know
that
that the telephone companies in the United States have cooperated with this program?
Even if that were the case, for this case to be justiciable and for it to have Article 3 standing, there must be that allegation in the petitioner's documents, which is not true here. But we are not saying that if there were another case where that could be shown and without using state secrets or other documents, that case would not be justiciable.
Well, I was thinking perhaps we were moving on to the merits as to whether this program does violate FISA. And so would you say that it does violate FISA if any of the tapping is done in the United States?
Your Honor, it would not necessarily violate FISA because Section 1809A allows for authorization by statute, and as submitted in our brief, the
but at least it would be within F4 if the tapping is done in the United States. And then your only remaining argument is that this was authorized by the AUMF.
That's correct, Your Honor. Were FISA to apply in that situation, then yes, that would be our argument about 1809.
What about one, before we end this with FISA, what about one? If the contents are acquired by intentionally targeting the United States person. Now, if you know that is absolutely certain as a result of your listening to a person abroad whom you'd like to hear both sides of the conversation, and you know that Jones inside the United States is talking to him, are you not intentionally targeting Jones as well as Smith?
No, Your Honor,
Why?
you're
Because?
intentionally targeting and trying to wiretap the communications of the person abroad, and that is what Attorney General Gonzalez conceded and General Hayden before.
Well, they might have. I mean, those are fine legal authorities. But the question that I would have is if, since I guess maybe at least the 4th century, if in fact I blow up the carriage in order to kill Smith, and I know perfectly well that Jones is sitting next to him, I've certainly intentionally killed Jones, even if I love Jones.
That's right, Your Honor.
All right, we all learned that in law school. They taught me that in the 4th century. I thought that the known consequence of an intentional act is intentional. And here, the known consequence of the intentional act, targeting my friend Smith, who's in Libya, is to pick up Jones. So why isn't that equally an intentional targeting of Jones?
Because, Your Honor, Congress, again, spoke very clearly when it talked about intentional targeting, and this ties in.
Why didn't they use the traditional word willfully? Or say, or go ahead, I didn't mean to cut you off, though I did.
Yes, Your Honor, that's perfect. That's
ahead.
perfectly up to Congress to add that word in to address Your Honor's concerns, and Congress had the benefit of the Sixth Circuit's opinion issued a year before its latest 2008 amendments, and if it wanted to address the gravamen of the problem there, which is to say electronic surveillance and its definition here in subsections F1 through 4, it could have done so but has chosen not to do so. And there's no telling necessarily what Congress would do if it wanted to change that and to impede on the president's
What's
more
the
power.
word that's helping you there? What's the word? The two words are intentional targeting. And what's the word that you're relying on?
Targeting.
Targeting.
That's right, yeah.
Fine. Targeting. Right. And so now, where it is a lawyer and a client involved, and if in fact, or a lawyer who has a client and a witness, is it fair that under some circumstances you would be targeting both lawyer and witness? Because you'd like to hear what the lawyer says to the witness and what the witness says to the lawyer.
And that hypothetical, Your Honor, would be the targeting, the notion of intentionally targeting with those words working together with their plain meaning would be only the witness you're targeting and not the lawyer who...
Well, wouldn't it depend on the state of mind and the intention of the person who runs the machine?
Yes, it would, Your Honor.
All right, so that seems, they are alleging that there is a state of facts that falls within their complaint, and that state of facts is an example of intentional targeting, targeting the conversation between the lawyer and Smith, the family member, the witness, the knowledgeable person abroad.
But in that instance, Your Honor, that would be with the case at bar today, that would be an allegation without proof. And without proof, there cannot be a justiciable case here under the injury in fact test. And there must be a situation in order for the petitioners to have standing wherein they could show that the government official who was operating the machine was intentionally targeting also the lawyer for the purposes of listening to that conversation. But that is not at issue before the court, nor is it in the record here.
But the word targeting isn't in F4 in any event, and so all that's required for F4 is that there be a device within the United States. And was there an allegation regarding that?
No, Your Honor, there was no substantiated allegation regarding where the wiretapping is occurring, either in the United States or without the United States.
But let's assume that one could infer from the government's concessions, the public statements regarding this program, that at least part of the wiretapping is done within the United States. What is the argument that the AUMF is authorization?
The argument that the AUMF provides authorization stems from its notion in Section 2A of the AUMF that it authorizes the president to use all appropriate necessary...
Let's assume that instead of the AUMF, Congress had actually declared war. Would that be... How analyze that case for us?
In that case, the president's full war powers would be triggered, and we would see a situation where we are in Justice Jackson's concurring opinion in Youngstown, where the
putting
president's
aside all the Youngstown and so forth, I'm interested only in the meaning of FISA. Doesn't FISA have a specific provision in it with respect to war?
Yes, it does, Your Honor.
And what is that?
That's provision 1811, which gives 15 days without a warrant during wartime for surveillance to happen with certification by the Attorney General.
And so if the government, if he gets 15 days with a real declaration of war, and you're asking us to say that with only an AUMF, which seems a little shy of a declaration of war, I'm not sure how shy, but a little shy, that he gets everything. Why don't we say that at most the AUMF gets the president what he would have gotten if we had gone to war?
That's because Congress decided to leave out of FISA's coverage the type of surveillance going on under the TSP, but assuming that FISA even applied.
That requires, I mean, we've gotten beyond that, at least for hypothetical purposes, and now we're talking about whether the AUMF authorizes the president, notwithstanding coverage under FISA. And that requires us to, I think, to say that the AUMF is a vastly more potent tool than a declaration of war would have been.
Your Honor, the AUMF in Section 2B addresses the War Powers Act and provides the President the necessary tools he needs to be able to go forth and use
So it
these
says
powers
for
to protect
purposes of
powers.
the War Powers Act, the AUMF is as good as a declaration of war.
That's right.
And I'm saying that if, for purposes of FISA, it is only as good as a declaration of war, it would have only have gotten 15 days.
Unless otherwise authorized by statute as in 1809A.
You know, you keep
which is what
that's
would
not
happen.
what the statute says. That's what the statute used to say. FISA now says in B, only an express statutory authorization for electronic surveillance. That's what FISA now says.
That's right, Your Honor.
And that's not the IUMF, right?
Well,
It's not an express authorization for electronic surveillance, nor is it an amendment to the statute. Those are the only two exceptions to FISA under FISA itself. It either has to be an express amendment to FISA, right?
That's right.
And the IUMF is not that, correct?
Correct.
Or it has to be not just statutory authorization, but only an express statutory authorization for electronic surveillance.
And
That's
well,
Congress, not me.
that's right, Your Honor. That is Congress.
How
but
can, how can the IUMF possibly be viewed as an express statutory authorization for electronic surveillance?
Your Honor, we submit that it should be viewed as express statutory authorization because the notion
Well,
of
you
necessary
left off the
appropriate
last
force-
part of it.
Express statutory
You don't like the
authorization.
language of the statute any more than your colleague does, right? You have to live with the whole statute. It doesn't say express statutory authorization. It says for electronic surveillance. Where in the IUMF do you find an express authorization for electronic surveillance?
We find that in this court's jurisprudence with respect
No, I asked you where in the IUMF.
to all necessary and appropriate force.
That's an express authorization for statutory,
That's
for
right.
electronic surveillance?
That's right, Your Honor, because it incorporates
So you don't think
President's
the
war
amendment,
powers.
you don't think the FISA amendment had any consequence?
Your Honor, I think the FISA
Right.
amendment may have had consequence if petitioners could bring forth a case in which they show that subsections F1 through 4 apply, and Congress
No,
could
no,
amend that.
no, we're assuming that it does. This is a question, we're assuming you're wrong about that. You've just gone back to your electronics. Let's assume you're wrong about that. Assume you're wrong that this is electronic surveillance. Assume you're also wrong about your argument about aggrieved parties. Assume they're aggrieved.
Yes, Your Honor.
Then you're faced with exactly the question we're asking about. You only can win if the IUMF gives you the statutory authority under sub B, correct?
Well, Your
Because
Honor,
you've
we can-
agreed it's not an amendment to FISA.
That's correct. It's
Okay.
not an amendment to FISA.
So, and the statute used to say statutory authorization, and Congress changed that.
That's right.
So you might have been able to win this case before the amendment. You would argue that this is statutory authorization, right, for force, and force includes electronic surveillance.
And force includes
But Congress
all-
took that argument away from you when it said express statutory authorization for electronic surveillance.
With respect,
We
Justice
have
Tatel,
to
I
give
disagree.
meaning to those words.
Your Honor, we are adhering to those words in saying that Congress provided the President with war powers, and those words are necessarily broad because the conduct of the war will necessarily require that the President be able to use tactics which help him be expedient in the war effort, and as this Court noted in Boumediene, Justice Kennedy, the conduct of war and national security requires both a sophisticated intelligence apparatus and the ability of the armed forces to act and interdict, and as a
So
result...
what do you think Congress meant when it used these words that I read to you?
It is our belief that Congress meant to provide the President with his war powers, his national security powers, to go after al-Qaeda and associated groups who help
No,
perpetuate
that's
the attacks.
that's the IUMF. I'm asking you about what you thought Congress meant in this language from FISA.
I think Congress meant that if it was proven in a court of law that people were able to prove that something fell under its definition of electronic
No,
surveillance,
but
which I understand
my
we're assuming
question
again.
is based on the assumption that it is electronic surveillance.
If it were electronic surveillance, and if we also assume for the sake of argument that Congress meant not to convey express statutory authorization, then the President would be acting in his lowest ebb of power under Youngstown, and
Right.
then there would require, or at least be allowed a situation where the political branches of government to whom the Constitution provides war powers to confer and find a solution which would allow the president to continue national security protection.
Well, your argument then essentially is that the president has the authority under Article 2 of the Constitution to ignore statutes that limit his power.
No, Your Honor, that is
Isn't
not
that
an
what you're
argument to
arguing?
ignore statutes. But his power would be more limited in this instance, as Justice Jackson noted, and as a result, that would at least do one of two things. First, it would either allow the president to confer with Congress based on the factual situation at hand and to try to work out a democratic solution there, or
Well, that's what happened when they passed FISA. Congress passed it, the president signed it. Isn't that exactly what happened?
no, Your Honor, because
Sure.
the president still can interpret the law and constitutional law to make sure this program
Congress
is
obviously
valid.
didn't want him to interpret the phrase statutory authority as broadly as he had been. So they changed it.
No, Your Honor, the Congress did not change it to change the very essence of what's going on
Why
here
are you
under the
being so
TSP.
timid about acknowledging that your position
Right.
is that under some circumstances, Article 3 authorizes the president to ignore statutes that cut into his Article 3 power? Isn't that your argument? I mean, your final, after going through about 4 or 5 other arguments, isn't that your final argument?
Our argument would be that the president would then be able to confer, but yes, that he might be in violation of specific statutory commands by Congress with respect to his conduct of the war.
So how can we tell that with respect to this matter, that is a surveillance of international communications, that that is within the core of the president's unalienable authority, and that Congress may not dip into it?
If we were to assume that we're in a situation where the president is expressly in violation of such a statute, then we would look to, which are not the facts in this case, but we would look to the president's powers and say that he's in its lowest ebb of power, and you could rule on that basis from Youngstown.
So it's lowest ebb, but you say even at its lowest ebb, he sometimes is going to win.
That's right. If
Right,
it's
and so
part-
I'd like to know, what's the argument that even at its lowest ebb, that this is at the core of the president's power? What's the argument?
The argument would be one of two things. The first argument would be under state secrets, that we have a situation where this is not a justiciable case because this court has decided, because it would be a terrible situation where national security was compromised, the ability of our intelligence services, the CIA and others, and the NSA to interdict.
Now, that would
damaged.
not be an argument on the merits that the president has this authority. That would be an argument that this court may not hear the case.
That's correct, Your Honor.
All right. But what about an argument on the merits that the president has the authority?
On the merits, Your Honor, we'd have to go to the president's power to conduct war, and Article 2, Section 2 is the commander-in-chief, and that it fell squarely within that power to survey, to get foreign intelligence.
Why does it, imagine getting around the other argument? Suppose the words "use all necessary and appropriate force" do include, under some circumstances, the possibility of surveillance, all right? Now, it still has to be necessary and appropriate. And all that's required under FISA is you go to a special court. Indeed, that's a security court. It has special procedures. The people appointed are all very, very secure. It is the most secure thing you could possibly imagine. And all you have to do is go and ask them for permission. Well, why is it necessary and appropriate not to do that simple thing, where what you want to wiretap or survey is where there is no war in the sense of millions of being killed or things like that. All you want to do is survey a conversation between a client and a witness. Just go and ask. Why is it necessary and appropriate not to do that simple thing?
Mr. Chief Justice, I see I'm out of time. May I answer your question?
Yes, you absolutely.
Thank you, Your Honor. In response to your question, I would say that this is a war on terror, that the president is acting upon a different war with different kinds of enemies, which requires a different kind of security apparatus, and is within the president's sound and considered judgment to figure out the most effective conduct for that war.
Thank you. Mr. Bennett, 5 minutes, 6. Yes, Mr.
The Attorney General has admitted, Your Honors, that this type of surveillance is the type that
Yeah,
finds more.
but he hasn't admitted that the conversations undertaken by these particular plaintiffs are subject to it.
Yes, Your Honor, but he's admitted that the types of surveillance,
It's
the
not-
government has been engaged in activity that would require a FISA warrant.
Is this a standing argument you're making?
This, Your Honor, is a merits argument. The program is illegal under FISA. It'll come to standing. The program is illegal under FISA. The government did not dispute that below. It's an admitted fact. It's in the record. It's not disputed. It's before the court. The program violates FISA. The AUMF does not provide, as you asked, express statutory authorization for electronic surveillance. And the question before the court on the merits is whether the president can break the law in the war on terror.
So you say that the Attorney General has conceded that this falls within FISA's definition of electronic surveillance.
The Attorney General has stated that it falls within the FISA definition, and the government has not disputed that statement in the proceedings below.
But they certainly have argued exactly the contrary in their briefs all through this case.
But when it came time to submit the statement of undisputed facts, they did not dispute that statement.
What was the context of the Attorney General's statement?
The press briefing, Your Honor.
But what were the words after, before, and after? Did he say this is the sort of communication that would fall within FISA if it were entirely within the United States? Or I don't know what other words there were. What was the context?
My understanding, Your Honor, is it's not qualified. I'd have to refer to the record to answer your question fully.
So your position is that the lawyers for the government here have just been out and out violating or disregarding the instructions from the Attorney General?
My position here is that...
Why didn't you move for disqualification?
Because we moved for summary judgment instead. We're going to win on the merits. Your Honors, the program is illegal under FISA.
But you still have to be, you still have to meet the statutory definition of electronic surveillance, correct?
Yes, Your Honor, but the government's attorney here has argued that we have to win this case on the merits. We have to prove...
No. He's arguing you don't have standing.
He's arguing that without the merits of this case, without checking every box on the merits and basically winning this case...
No, he says you don't get to the merits. He says either one of two things. Either you lack standing, or you don't have a cause of action under FISA.
But for the same reason...
And you agree you have to have both.
Yes, Your Honor, but for the same reason that Justice McConnell's river analogy was unable to go answered by the government's attorney, we have standing here. It's a reasonable fear...
I was asking you about FISA.
Yes, Your Honor, it's a reasonable fear that we could be targeted by FISA. The reasonable fear...
But to have that fear, you have to be engaged in electronic communications that are subject to FISA.
And back to the merits, Your Honor, Section F1.
You know? This isn't merits. This is whether you have a cause of action.
Okay. The cause of action comes from the violation of subsection F1 in FISA, intentionally targeting a known individual in the United States.
And why is it likely that your clients have been targeted? I see why it's likely that their calls have been picked up, but it's the folks over in Europe and Middle East that have been targeted.
Right.
Yes, Your Honor, it's intentionally targeting communications with known individuals in the United States.
Who?
The known individuals in the United States would be the attorneys at law who represent the people the government is proceeding.
Has the government chosen to wiretap in order to get them?
The attorneys, but it doesn't say, Your Honor, it says
what does targeted mean?
It says intentionally targeting communications, and it says known individuals in the United States. I think we're going too far into the details of the statute here. It's designed to distinguish between electronic communication and things like...
I think it's designed to distinguish between the target of the wiretap and other people whose communications happen to be caught up in it.
No, I disagree, Your Honor. It's designed to distinguish between things like...
target is a well-defined term in criminal justice enforcement, right?
Absolutely, Your Honor. But
it's the person they're going after.
Consider other types of electronic communication, like an FCC radio broadcast. These are the types of things that FISA is trying to distinguish. It's private, personal communications. It's electronic communications with known individuals. These are the types of communications that program...
So you don't talk about F4, which I'm surprised at. Why? I take it that you think F4 is not as strong as F1.
Your Honor, F4...
Is that because you concede that there's no evidence that there are any devices within the United States?
We concede that the government will invoke the state secrets doctrine, and we cannot get around that.
And you can't get around that. So F4 is out.
F4 is out not because
So you really have to persuade us that the people whose calls are caught up are the targets. Maybe you should take one more chance to explain how the word target could possibly apply to your clients.
Your Honor, I'm almost out of time.
Well, let me just ask you a related question. The government, the dissenter in the Sixth Circuit said the government waived this argument. Are you not raising that because the dissenter was wrong?
Your Honor, the dissenter was absolutely right.
Well, then why isn't that your answer to all of this?
Well,
that the government didn't raise this below. It's waived. I didn't see that in your brief.
That was the argument I came to the rebuttal podium here with.
Wait, but I didn't see it in your brief.
No, Your Honor. it's
Well,
not
you
in the brief.
can't raise it then. You've waived the waiver, right?
I have waived the waiver. Your Honor,
Or forfeited the forfeit.
Forfeited the forfeiture. Either way.
I'm out of time. I'd like to ask for reversal of the Sixth Circuit.
Thank you both very much. Thank you. Thank you. Very good.
All rise.
Ladies and gentlemen, give it up for Patrick McBaine. You may be seated. So, Patrick, Brent, I am really so proud of you. And I am also so glad that it was you up there. You know, it's a bittersweet experience for any teacher in this area to see their students so exceed both their expectations and exceed what their teacher could ever hope to do themselves. So congratulations to both of you. Both of you, you know, people say this, but it's true. Both of you are winners. Okay? I am going to take this opportunity to thank and to honor 3 different groups of people while the justice and the judges are deliberating as to who has won the McBaine competition. First of all, I want to honor the winners of the Best Brief Award for the McBaine competition. This is fire and lightning, but cases are won and lost on the briefs. So I'm going to ask 2 people to come up and join me up here. I hope you will give them a very warm round of applause. The best brief for petitioner goes to Bejan Fanabanda. The best brief for respondent goes to Lisa Stockholm. Thank you, Bejan and Lisa. I'm going to take this opportunity to talk just briefly about another aspect of the Moot Court Board of Advocates programs that Board of Advocates oversees. This organization runs the McBaine competition, but it also oversees many outside competitions where UC Berkeley students go off to compete against other schools. Now, over the course of the past 3 years, there have been so many highlights and so many first places, and it would be boring for me to tell you about it. So can I just tell you about the last 3 weeks? In the last 3 weeks, we won overall the trainer competition, which concerns California law. We came in second place in the regionals in the Giles Sutherland Rich competition and are going to nationals, where of course we're going to win it. And then finally, there's an international competition called the VIS competition, which is in Vienna, Austria. And our team went to compete against 233 other teams from across the world. And these teams, some of them, quit school for a semester simply to prepare for this competition. Our students did not do that. But one of our students came in second overall in oral argument out of 1,000 competitors in 233 teams. So that's the past 3 weeks. So I hope you'll acknowledge all the members of the Board of Advocates. For those of you who are currently first years or second years in the law school, consider whether you want to be part of this team. And if you do, look at the door at room 377 and sign yourself up for a tryout. Okay? The last thing I want to do is I want to recognize a group of people who really have made this possible. First of all, this competition could not have run at all without the extraordinary work of two students. Karis Gong and Katie Cameron have done just an extraordinary job on this. I'm going to also mention in the Dean's office, Marilyn Byrne, Elaine Moy, Nancy Donovan, Sarita Shepard. In Alumni and Development, Megan Tennisgetter and Dana Gandhi, Susan Gluss in Media Relations, and then my assistant, Barbara Anderson, who kept me sane. These people made this happen. I really appreciate what they've done here. I'm going to ask you to hold your applause. I see many, many old friends of this program in the audience, many of them, and I really appreciate all you've done this year and in the years past to make this program so successful. So thank you very much.
All rise.
Well, it was a very, very good argument. It was very, very close, and I pity any lawyer who had to argue before this panel. My God. And it was very, very, very close. They both did a very good job of standing up under what I would call inordinate pressure. And we've ended up thinking by virtually a hair, it's Mr. Nakamura wins the I'll turn to each of my colleagues to say something. Judge McConnell.
This is a pleasure to do this and to hear two such fine young lawyers in such a hard case. I'm glad I don't have to decide the merits of this. The doctrinal shoals that were waiting for both of you were really quite formidable. And before talking a little bit more about counsel, I just wanted to add a word to whomever it was in the moot court bureaucracy who put together this extremely difficult problem, and comment that especially it was good to have the record that we had here, because it, I think sometimes in moot court the facts just sort of appear out of nowhere and you don't know where they're coming from, and that always leads to a quite unrealistic argument. And so this is, I think, a much more well put together problem than we often see. And of course, I'm sure everyone can tell how difficult it was for these competitors to have to master so many areas of tricky, difficult law. Just to comment about some of the things, excuse me, beginning with the issue of poise. I think both counsel today showed an unusual degree of poise, even when sometimes getting a bit battered. Oftentimes you just see lawyers practically fold, and both we saw a lot of resilience coming back. Each of them had particular aspects of their argument that was stronger than the others, and they were quite good at trying to bring the argument back to safer territory. Both of them also were quite good at picking up on details in the record when being questioned about them. For example, when Judge Tatel was asking about the Nancy Hollander affidavit, they didn't say, well, you know, who? It was like they immediately knew exactly what was there and were able to connect with that, and that's something that was very impressive. You do need to be very careful about concessions. It is valuable to concede points that you have to concede, but it is dangerous because sometimes it's a mistake, and and the concession needs to shore up a very powerful other argument. And Mr. Badgent, I'm not sure all the tactics that went into your decision to put virtually all of your eggs in the F1 basket, but I think that may not have paid off as much as you would have liked. It's also quite important to answer directly. I felt that this might have been maybe a weakness of both counsel, that there were times when you were being asked quite direct questions, and because you didn't like the questions, you gave a very sort of circumlocucious response to that. Just, one example, although I don't want to pick on Mr. Nakamura, but just an example, at the very end of the argument, you were asked, why not just go through the FISA process? And your answer was a bit abstract, right? I would have thought you'd want to say, well, the reason is it takes too long, that these guys, by the time we find out where they are, they're making a communication, but if we went to the FISA court, fast though they are, 24 hours, it's still, they'd be away. That kind of more direct, practical, immediate answer is better than a kind of abstract answer about how the president has made his firm, intelligent choice to go whatever way it was. So that's, but in general, I really thought it was an outstanding presentation on both parts, and I really congratulate you both, and encourage you to come out to the 10th Circuit and argue some cases in front of us. It would be great to have you.
Judge Tatel.
Well, I want to reiterate what Judge McConnell said about the quality of the oral argument. I thought the two of you did a terrific job, in all respects. You should be very pleased with your performance. You were prepared. You knew your cases, you knew the law, you knew your record. Those are all signals of a well-prepared oral advocate. Just a couple of thoughts. One is, I thought you both did a particularly good job in stopping when a question was asked and answering it. Now, you may think that's a surprising statement, right? Why not answer a question that a judge asks? Well, you should come visit the D.C. Circuit someday, because there are a lot of lawyers who don't seem to get the basics about that. They either talk over the question, or they don't answer the question, or they think that they can avoid the question. And what they don't understand is that these questions are coming from three judges who have to decide the case. And they have questions about the case. They aren't trying to trip up the lawyer. They aren't trying to embarrass the lawyer. They're actually trying to decide the case. And so I was really impressed that the two of you stopped and listened. We weren't always convinced by your arguments, but sometimes you have a strong case and sometimes you don't. But you're way ahead of a lot of other advocates. Second point is, as you probably could tell from our questions, the words of statutes matter. Professor Frankfurter, when he was a teacher, used to tell his students, number one, read the statute. Number two, read the statute. Number three, read the statute. The fact is that a case like this, both parts of it, whether you have a cause of action or the merits, since the Fourth Amendment wasn't argued, turn on the construction of a statute. And that means you need to pay very close attention to the words Congress uses, because that's what the courts will follow. And I thought, you did a pretty good job of that. For some of you, the language of the statute helped. For others, it didn't. But you want to pay very, very close attention to the words of the statute. And related to that, you want to pay very close attention to the technical aspects of an appeal. You want to make sure the issues are properly raised. You want to make sure that they're raised in the right way. This case sounds great, right? War powers, electronic surveillance, state secrets. But it could well turn on whether an issue is properly raised below. Or it could turn, as Judge McConnell said, on an inappropriate concession. That's what oral arguments are for. It's very, very interesting. The last point I want to say is that, as you probably both now understand, oral argument is lots of fun. Oral argument, it can be scary, but if you're prepared, if you've really prepared your case, I think there's nothing better in the law than arguing a case before a prepared panel. It's the best you can do as a professional. You should think when you're doing it that you are actually participating in the process of deciding the case. That's your chance to influence how the three people who are going to decide the case will think about the case, and I thought the two of you did a very, very good job of undertaking that. So congratulations.
Thank you. I'd agree with my colleagues. My goodness, we were difficult. But we, in being difficult, had to find ways of distinguishing between you, which wasn't easy to do. I'd say one thing about the case. This is not a normal case. This is a very difficult case, and it isn't difficult in the sense that a chess puzzle might be difficult or tax law might be difficult. It's difficult in the sense that you're dealing with very amorphous areas of law. Standing, the more you look into that, the more it dissolves. You're not certain what it's about. The war powers, that arises very unusually. Statutes and how they relate to the war powers, of course, look and read the words of the statute. That's where you begin. But how we figure this out, I don't know. On top of everything else is floating this thing called official secrets, which I'm not even certain what it is or where it applies. So we have here what Churchill called a riddle wrapped in an enigma surrounded by a mystery. That was the case that you just heard. And don't think it's a normal case in the law. It's a very interesting case. It was a very hard argument. And the faculty and the people who put this together did a very good job, and you did a good job at taking so amorphous a subject and putting form on it and arguing in half an hour. As to the lawyers, I would agree with what my colleague said. The strength of this, and it's never perfect, the strength of it is that the advice that I had when I was being confirmed, which was not I had to go before the Judiciary Committee, 17 senators are going to ask you whatever you want, and it's on television, and if people don't like you, and they're not judging you as a star, they're pretty tolerant. But this is stressful, and oral argument can be stressful. And the advice I got there, which is what you did, is one, listen to the question. Answer that question, not some other question. And take your time. They can't force you to answer immediately. You don't have to blurt it out. You can think. You have a minute or two, or at least a second or two. And fine. And you did that, I would say, pretty well. I thought it's hard to argue in our court. We have 9 members. It's very difficult. The lawyers have to know the record, and you did know it. They don't know quite what question you're going to get, and I think we surprised you some. And you have to be able to answer in a way that will help your client. So advice to me that I was given, which I'd pass on, listen to the question, answer the question, and Mike Berman, who was the one who told me this, said, and don't try to show how clever you are. The object is not to show how clever you are. The object is to be confirmed. It's very important in this context of oral argument. The object is not to show you're a better lawyer. The object is to win the case for your client. And you're dealing with 3 people, perhaps 9, who have a different object. Their object is to try to get this right. And it's hard to get it right. And you took the case of all time, just about, that's really hard to get this one right, because there are a lot of important things on both sides of this question. So what you could tell from your argument was you were interested in this argument. You were interested in it. You'd thought about it. It wasn't rote. You were responding to the questions. And that was pretty good. I'd say that was very good. And the rest of you are not all lawyers. Some of you are. Some of you are a family. And if you're related, you should be proud of those whom you are related to. And those who are law students will do a lot more of this. But I couldn't agree more with what's just been said. Interpretation of the law, which is what we're involved in, is a question of getting things right under circumstances where there are usually 2 rights, one on both sides, and each has an interest that we're trying to protect, and it's hard to make that combination in a really difficult case like this one. And so we see you, the eventual lawyers, as people who are put there to help us. And you see yourselves as, well, you'll help us all right, but you want to win this case. And it's out of that kind of crucible that interpretation, for better or for worse, emerges. And it's easier to sit in our position in many respects in terms of stress, and then sometimes not. But still, it's a wonderful thing what you're doing, and I see that you're learning it here, and I'm glad that you are, and I'm glad your fellow students are learning the same. And I think I can say on behalf of the 3 of us, we thank the law school here at Berkeley very much for inviting us and providing us with such an interesting case experience and such a well-argued case, too. Thank you.
All rise.
Thank the court.
Thanks for coming.
Court is dismissed.